take the chance.
I pray every night! I pray!
You know I'm a gang member and stuff. Well, I f***ed up. I f***ed up. That phrase, I f***ed up, Judge.
Because I don't know if you're going to put another family through what you putting us through.
A video showing the arrest of two black men, Ricky and Travis Price, went viral on June 23, 2021, capturing officers beating them, which led to social media outrage and 3 days of protests. On July 2nd, investigator Jonathan Soto testified in court regarding the incident.
Moreno noticed Travis Price approaching officers who were dealing with Ricky. Investigator Moreno approached Travis as he began to yell at special agents, telling them, "You don't need to point in his face." Moreno walked up to Travis and backed him away from the officers who were dealing with Ricky Price. As Investigator Moreno backed Travis away, Travis began to push his body into Investigator Moreno's hands, passively resisting. Investigator Moreno and Special Agent Justice then took Travis Price to the ground to detain him. Ricky was not in handcuffs and saw that he was resisting Officer Palmer and Special Agent Duggar. As Investigator Soto ran up to assist officers, Ricky Price Investigator Soto in the face with his left closed fist. Watson arrived on scene to assist and Officer Palmer retrieves his canine, Nicky, from his patrol vehicle. Ricky Price continued to fight officers and resist by kicking Investigator Soto and pulling his t-shirt. Watson delivered a strike to Ricky Price's face, striking him in the nose. This caused Ricky to stop actively resisting officers. Ricky became compliant and was placed into handcuffs, and all force was seized. During this incident, Special Agent Duggar's thumb was dislocated. Special Agent Duggar retrieved the first aid kit and provided first aid for Ricky Price's nose, which was. Investigators then called EMS to treat the injuries sustained during the arrest.
The city of South Carolina paid a $500,000 settlement to Price, whose treatment by a police officer during what turned out to be a false arrest led to days of protests. Patrick Norett has a chance to be free. He was found guilty of first-degree murder and sentenced to life in prison without the possibility of parole for the killing of Jean Strandberg during a robbery at the liquor store where she worked. Jean was a kind woman who often gave him candy if he couldn't afford it. At the time of the crime, Norett was just a teen. He admitted to helping with the robbery and even handing the gun to his accomplice.
Took the gun, wiped the gun, gave it to him, and
But there's never been an allegation that Mr. Norett actually pulled the trigger.
Patrick Norett chose not to accept a plea bargain and went to trial, where the jury found him guilty. Until recently, he believed he would spend the rest of his life in prison. However, a Supreme Court decision has opened the possibility for juveniles tried and convicted as adults in first-degree murder cases to have a second chance at freedom. Despite this, there seems to be little hope that Norett will be granted parole.
More concerning to me is the things that you continue to do in the institution as an adult.
Norett has faced several disciplinary actions while in prison, including stabbing another inmate. The most recent incident occurred at age 39 when he got into a fight, now 43. The parole board noted that he hasn't participated in any rehabilitation programs for anger management. His lawyer argued that the correctional facility in Maryland, where he is currently held, lacks appropriate programs. Still, it was the facility the Department of Correction assigned him to after his fight in Massachusetts. The lawyer requested that if the board denies parole, they clearly outline the reasons for their decision so that Norett can understand what steps he needs to take to improve his chances in the future.
Could use that as leverage to get DOC to send him someplace other than Maryland.
There is no set deadline for the board's decision, but Norett remains hopeful. He pleaded for a chance to return to Haiti to start over near his family before he became too old to work.
take the chance.
Patrick Norett was initially sentenced to life in prison without the possibility of parole for first-degree murder after being found guilty of killing Jean Strandberg during a robbery. However, following a Supreme Court decision allowing juveniles convicted as adults to seek parole, his case is under review by the parole board. The board has yet to make a decision on whether he will be granted parole. A judge in Lucas County found Shante Hardin guilty of 31 charges in Ohio. Before he was sentenced, the victims of his crimes read heartfelt statements about how the situation affected them.
I have so much hate for you, Shante. I have so much hate. Hate, I wish misery upon you, your family, and your soul. I want that. I pray for that. I pray every night. I pray that something happens to you, and you are treated like you treated my son.
It scares me for you to be in the community. It scares me for you to walk out there. Because I don't know if you're going to put another family through what you putting us through. You lied! You lied to me!
There has been a big contention, as if I'm not apologetic to the families. Anytime something goes wrong or somebody's dissatisfied, I'm always heartbroken, both personally and professionally. But I was always doing my best to help where they asked me to.
He saw in this funeral business an opportunity to take advantage of people at the worst time one of the worst times of their life.
You ruined my son's memory. You ruined it. Every time I think of him, this ugliness that you put on me, it overstands the memory.
And I go see my baby in a box, foaming at the mouth with green on her skin, turning green. I am a mental health specialist, and I can't get my own mental health in check. I can't help my clients without seeing my sister's face.
Shante Hardin was sentenced to nearly 12 years in prison for operating an unlicensed funeral home business. Julia Phillips, a convicted murderer, was recently back in court due to a probation violation. She faced accusations of failing to pay over $1,000 in court-ordered restitution, which was a condition of her probation related to a felony breach of trust charge. This violation could potentially impact her probation status, leading to further legal consequences depending on the court's ruling.
She's here before Your Honor today, charged with felon pay supervision fee, felon pay restitution, felon cause vice instruction of supervising agent, and the victim of the case is here, Your Honor, would like to address the court at the appropriate time.
Sure. Ms. Stubbs, you got Ms. Stubbs?
I do, Your Honor.
Ms. Stubbs, you heard what the agent has told me. Do you admit that?
Yes.
All right. Stubbs?
Your Honor, the recommendation of probation is to terminate probation and issue a civil judgment. And that's what we would ask to do. We were willing to do this with consent order, but I'm out to the television stations here, and I'm going to be newsworthy about that, but apparently bullshit, but he'll keep what they can off the phones. And we just asked for a long recommendation to terminate. She's doing a life sentence, she'll never get out of prison.
Yes, sir. We have to hear from you. But you state your name first, please.
David Roberts.
Yes, sir.
My father was the man she was convicted on September the 5th, I think it was. What I wanted to bring your attention was, she currently still owes, I consider my dad, $1,087.46. The thing about this is, she was stealing his money from my father. And the thing that's always been very troubling to me was after my father's murder, I got a phone call from a gentleman who lived in apartment 3, which is what this is all about, the building with my father, asking where to pay rent. And I said, well, I've got an empty apartment, apartment 3. He said, that's where I live. Really? I said, yes. He had all these receipts where he'd been paying her, but she had not given money to my father. So then, he told me that she had called him, he called me on February 17th, which was my father's murder on February 4th. Then on February 16th, which is 12 days after, she had called trying to still collect rent money from my father after she murdered him. So, I just want to let you be aware of that. Just what I'm asking for today, they're asking for a civil judgment. So I'd like to ask for, in addition to civil judgment, any any financial gain she may derive from any source between now and her death would be used to pay this restitution to my dad. If that's possible.
Say that to me again.
If there's any way, if there's any potential revenue that she could derive from any source, right now till she dies, that money be used to repay the $1,087.46 she owes our father.
I don't think I can order that. I think it may be a civil matter. Okay. And I'm sorry for your loss, but I think the only thing I can do today is actually what the state has asked me to do, which is terminate it to a civil judgment, and then if she has any financial assets, you could then levy against them. I can do that.
Okay.
All right. All right. Don't be over.
Thank you.
What was it like to see her today, to see Julia today?
Well, you know, my main thought was it will more than likely be the last time I ever see her, was actually more what I was thinking about.
The last time you'll ever see her?
Yes.
And your emotion in seeing her shackled and in the prison uniform that she'll wear for the rest of her life?
You know, that's where she needs to be. She's a convicted murderer, and she's where she needs to be. That's in prison until she dies.
Ronnie, what was your impression today?
I wanted to see what she looked like, and I wanted to see if she showed any remorse for stealing from our father after she murdered him. And she showed no remorse, just like she didn't in court. So she will wear this prison garb until she dies, and then she'll burn in hell for the rest of eternity.
She was sentenced to spend her life in prison. Erica Kenny, 23, and Chaynese White, 29, were charged with encouraging children at a Cranford daycare center to fight one another.
I just want to say that I love those kids more than anything in the world. I have a 3-year-old of my own, and I looked at those kids no differently than I looked at my daughter, or that I looked at my nieces or my nephew. I did everything for them. If they were here right now, I could put money on it that they would still run up to me and give me a hug. I loved them and they loved me. I would never want one of them to get hurt. It was a situation that I'll always regret. I know it was wrong. I know it should have been handled much differently than it was handled. And I'll regret it every day. And I know nobody's here for me to say sorry to, but if I could look them in the face and say, you know, Sarah should have handled it differently, I would certainly say.
They are going to hear your apology, I'm sure.
Yeah.
Okay. Anything else?
Is that obviously I would never let a situation like this happen again. I'm not the monster that they're trying to make me act.
Prosecutor?
I know she says that she loved these kids and she would never do anything to harm them, but she did do something to harm. She put them in harm's way. She let a whole entire classroom of kids fight each other, throw punches, kicks, push each other down, bigger kids on little kids, boys and girls. And then telling them, in fact, on the videotape, what happens there stays there. Okay? That she did not contemplate serious harm, well, that's the problem here. She should have contemplated serious harm because she's an adult and a teacher, and these kids were put underneath her trust and her care. And she abdicated that trust and that care in order to have fun and share something with the friends that she, A, should have never shared, and B, should have never let happen. And the teachers not only didn't stop it, but encouraged it. Not only did they encourage it, Ms. Kenny videotaped it and sent it out to other people. Parents pay a lot of money. Parents give up their trust and their care to these people. And these people can't allow this to happen.
They both received 3 years of probation. According to court officials, 14 juveniles from York County are facing criminal charges for malicious damage to property or petty theft related to social media challenges.
What's called the TikTok challenge. It was the September challenge, evidently. And Your Honor, it was very, very disruptive to our school system, and because of that, we felt that it was very appropriate for this juvenile to come before Your Honor prior to going into the arbitration program. We wanted him to realize how seriously we take this and how much trouble he could get into with this type of behavior. Just a brief summary, Your Honor. Basically, this happened back in September. It did happen at Rock Hill High School, and there is a video of this juvenile taking a soap dispenser off the wall of the boys' bathroom at the high school. He did damage that, and he was charged with malicious injury to property as part of that.
Well, you know, we've actually got, looks like around 14 kids at or near your age who are coming to court today because of engaging in this TikTok challenge. I also want TikTok removed from your cell phone, never to appear again. So you need to understand you can't do that. And I have no clue how it got to this point that we could have kids in our own schools destroying property. And this needs to be stopped now. And you happen to be the first one on the list today. So that's why you're getting the extra little bit of a lecture. But I want you to make sure that you spread the word to your friends that this TikTok challenge is not going to be accepted. And this one that's going on this month, if we find out that some kid has struck a teacher as part of this TikTok challenge, they'll be here in the courtroom and they won't be going through arbitration. I'm going to ask my deputy to open that door right there. And do you have any idea where that goes? That's good, you hadn't been here before, but it's a door that opens up into some cells. And you heard that sound with it closing? You don't want that to be the last time you say goodbye to mom and end up back there, going down in an elevator and going off premises with the deputy to take you to jail somewhere. We don't want that to happen.
The judge emphasized that their actions were unacceptable and warned of the severe consequences of such behavior. This was an unusual court scene, as the judge read transcripts of phone calls filled with profanity. It's not something typically heard in a courtroom setting.
I'm a gang member and stuff. Well, I f***ed up. I f***ed up. That phrase, I f***ed up, Judge, is sometimes used by drug users when they relapse.
In court, the F word was repeatedly used as the assistant district attorney read transcripts of phone conversations between Jessica Kelly, her friends, and her family. The judge also read these transcripts aloud, bringing the explicit language into the courtroom.
Talks too much and brags about his brothers. Fabian brags too much about his brothers, and he called on something that he didn't even know what he did.
The state argued that Kelly's prior drug use and some of the recorded jailhouse phone calls should be admitted as evidence at trial. However, the judge remained unconvinced, at least for now.
It doesn't say I was up, it says I up. That's
and she
what wait a minute, let's just take that. I mean, that's no different than any man who's ever made his wife mad.
The judge said he wanted to listen to the phone calls before deciding which ones would be permitted at trial. Additionally, he requested that graphic photos and videos of the crime scene be reviewed before they were presented to the jurors.
I will look at them, you can be here, and I'll rule on which ones I'm going to let in and which ones I won't.
The defense requested that the judge move the case out of Bernalillo County, arguing that the extensive media coverage has made it impossible for Jessica Kelly to receive a fair trial there.
The cat's out of the bag, Your Honor. We can't put it back in.
The judge responded that he wasn't ready to move the case, noting that Jessica Kelly is the first of 3 people to be tried in this matter. He emphasized that Bernalillo County had handled other high-profile cases before and expressed confidence that Kelly could receive a fair trial there. Prosecutors now claim that Aria Foster made off with nearly $1 million. The 19-year-old, a LaSalle University track athlete, had a group of supporters watching from the gallery in court as the prosecutor read the charges against her. Foster reportedly bought high-end items like a Tesla and designer clothes, took a trip to Hawaii, and worked part-time at a jewelry store in the Burlington Mall. In court, the prosecutor stated that she tampered with the store's security camera system. Here's how they believe she tried to pull it off.
A series of transactions were reported, 3 dates in question, and on the store's ledger, and it appeared that on these dates an item was scanned onto the register and the item price was altered to heighten the loss. The Item would then be refunded onto a credit card.
The investigators dug deeper and discovered that the incidents occurred on more dates than they first realized. Initially thought to be a $500,000 theft, it has increased to about $1 million. Besides the costly car and vacation, police say Foster also purchased a $5,000 Louis Vuitton purse. She has been released on a $1,000 bail. A Cordova couple, Henry and Leanne Harris, are accused of stealing hundreds of thousands of dollars from an elderly woman. The case dates back to 2021, and they appeared in court. The judge read the 4 felony charges against Leanne, including theft of over $250,000 and financial exploitation of an elderly person. Her bond was set at $50,000, and she said her father would cover it. Henry Harris also faced bond decisions, but confirmed with Leanne, and then informed the judge that Leanne was his wife. According to a police affidavit, Leanne, who was the power of attorney for the elderly woman, had access to her accounts. The victim's son later discovered that over $400,000 had been spent without his mother's knowledge or consent and not for her benefit. Instead, the couple allegedly used the money for purchases online, as well as making tens of thousands in ATM withdrawals and writing and depositing checks into their own accounts. Henry and Leanne Harris must return to court on August 15th, with or without an attorney. In January 2003, in Grand Rapids, a teenager named John Seisling caused a terrible tragedy by brutally killing his mother and sister. The city was shocked by the violence, and the court was tense as it awaited the verdict. When the victims and the perpetrator are family members, the pain felt by the remaining loved ones is deeply heartbreaking and evident.
Your Honor, I'm Laura. Sharon Seisling's best friend. I was godmother to 6-year-old Leah, and I had been asked by the family of Sharon, Katie, Aaliyah, and John to speak to you about the impact of the murder of Sharon, Katie, and Leah by John has had on the family. How do I describe the impact John's crimes have made on our family, friends, and community? At the age of 17 years, 5 months, a young man that we all loved brutally his 2 young sisters, his mother, our nieces and sister. Most people have experienced sadness that comes from the loss of loved ones. Someone you called good time, good news, bad, and just knowing that she was there. You know that it was like to reach for the phone and the overcoming pain and sadness and emptiness that the whole my heart when you realize your confidant is not there to answer. Sorry.
Take your time.
Okay. Sorry. Some experience the loss of a child and know the special pain of losing someone young. The family and friends of Sharon and her daughters experienced the pain of losing 2 very beautiful, precious little girls. We experience these pains, painful losses every day. We miss them all the time. Unlike most others, however, when we reach for the phone to call, Sharon's not there. And the grief and the memory, she's gone. Also experienced the anguish Sharon must have felt those last minutes as she tried to save herself and her daughters. Imagine your son beating you with a bat, breaking all of your fingers as you were trying to defend yourself, and then finally hitting you and bringing you unconscious. after being hit that hard, she did come and find where her strength to get up the steps and get the phone to call the police for help. And that's when, if you can imagine your son taking it steady you, starting low, and just keep until he hits your jugular, and then he out. These images, every time we think of her and experience her anguish, and she was a tough one, but it breaks my heart to think she did go through that in her last moments. The horror, the days following, we learned how the murders were. We learned that after knocking her mother unconscious, John went up after his 15-year-old sister, Katie. She ran outside across the yard trying to get away, but John hit her with a bat and knocked her out, bringing her back into the garage, where he hit her throat. He almost beat her. When Leah, she was out back playing with the dog, Elvis, just having a great old time, because what do you do when you're 6? It's snowing and the dog, and you're playing, and she had no idea what was going on. She had no idea. She came to the back slider door and saw her sister and her mother in a mess. He grabbed her, took her upstairs.
As this family member spoke about the deep pain caused by the tragedy, the criminal, who was also part of the family, could feel the heavy burden of the terrible crime he had committed.
That weighed so heavily on one of those poor young guys that he committed suicide. I didn't know him, but I know some of the family, and it breaks my heart that they had to go through all of this. No amount of therapy, medicine, alcohol, or time lapsed. Those memories, you don't raise them, they don't make them go away. It dulls them a little. You cannot recover from such loss. We will never be the same without them. We try to move forward, but each time anything about the tragedy arises, we are slapped down. Our hearts are ripped open in pain and unbearable. It's unbearable. It's like putting salt on an enormous wound. We try to heal, focus on positive things and all the fun memories. Sis and I were sitting there just talking about it. It just makes us laugh. And then again, and simply cannot express how excruciating this is for us. I cannot eat. I can't sleep. I can't enjoy anything. I cannot think of anything except the horrible, horrible scene of that day. This has been our state since learning of Michigan Supreme Court ruling that led to this chance for John to receive a parole. Oh, we are back in 2003, reliving every second of the horror. John was a young man who we loved unconditionally. And the day before the murders, I went through the newspaper with him and his mom, Cher, to find a job. And we giggled and laughed and did all kinds of stuff. Anyway, he was not on drugs. He acted alone to commit most horrific, gruesome murders The crimes are no less horrific today than they were 20 years ago. Less than 2 years ago, news reporters on John's recent sentencing state decidedly told the doctors that was pleasurable and exciting, and that he had thought of other inmates. Experts said John poses a danger to other inmates and would be a danger to the community if released. I, number one, have identified for myself and my family. And doctors included, those hired by the defense, had strong comments indicating John exhibited signs of having antisocial personality disorder. He was cruel to animals, including blowing up frogs and setting fires. Doctors described John as and dishonest, at the risk of recidivism. I know what it means, but I can't say it very well. Sorry, sir. Sorry. Is pleasurable and exciting. Signs of antisocial personality disorders, danger to the community, a risk to reoffend. We are terrified of John's release. I am sick to my stomach. I fear for myself, my children, my pets, my neighbors, everyone here in this courtroom. As you approach sentencing, please remember the crimes that John committed. The crimes are no less horrific today than they were 20 years ago. John, I'm sorry, I always called him Johnny, but Johnny brutally murdered 3 members of our family. They are gone. We, the living victims, struggle every day with the pain. Such tremendous loss in the images of that day. Please consider the 3 vibrant people that John, as well as the family, friends of Sharon, Caitlin, and Leah, and the many other classmates, law enforcement, mental health professionals that had been affected by these murders.
Your Honor, I do understand, and I apologize because this is emotional for everyone. Because I was in the office and I didn't try this case, Bill Forsythe did, but I've remained in contact with him every day while we were handling this, and even after. And I think Mr. Graff states it appropriately when she highlights how impactful this crime is on a community. It was on Bill Forsythe, it was on me for handling it, and it was on various members of the Walker Police Department, including Bert Elliott and Dan Rapp. And Bert Elliott's last day at the Walker Police Department was yesterday. He's now retired. And it really truly is not about us, but it does impact us. And most importantly, it impacts the people behind me, which is the surviving members of the Seisling family and the Moore family. Again, I do understand this court's ruling in regards to the modifications in the law. It does highlight the absurdity of those modifications, that a crime like this does not warrant a sentence of life without parole. But I understand, and I know this court understands too, that we don't make the law, we have to follow the law. And someone else interprets that law for us and tells us how you apply the law. I get that. However, it is absurd to me that you can your mother, your sister, and your 6-year-old sister is, as John Sisley did, and that does not warrant a sentence of life without parole. But it does highlight the fact that if there was ever a case where it is necessary to impose the maximum of 40 years, this is it.
John, since my incarceration, I've grown. I do my best to make myself a good man. Even though I never thought I'd see freedom, I participated in any program I can do. Any vocational training, anything I can do. Every day I wake up, I think the world was lost. And how my mother, Caitlin and Leo, want me to be a better person. And I try to conduct myself accordingly and how I believe they want me to be as a man. The crime that I committed can never be undone. I'm sorry it would never be enough. The loss can never be quantified. I do my best to live every day in an honor as best I can. Thank you.
In our first hearing some time ago, after several days of testimony, I determined that the defendant should stay in prison for the rest of his life without parole. Then the Michigan Supreme Court modified significantly the law that I have to apply. And I am a circuit court judge. I am not the legislature. I am not the appellate courts. I am not the Supreme Court. I have to follow the law. The only reason we are here today is because the United States Supreme Court, the case referred to as Miller, said that juveniles should not be given a prison sentence of life in prison with no possibility of parole, that it was cruel and unusual punishment. Our Supreme Court has extended that, and that is why we are here today, and that is the only reason we are here today. And I find it quite interesting that the Supreme Court of the United States, as well as the Supreme Court of Michigan, as well as the legislature, which has passed laws with regards to this, only focus on the juvenile murder. They do not take into effect at all in any of those cases the impact that these type of murders have on the victim, on the victim's family members, on the victim's friends, on the community, and even the police officers. We had a police officer testify that, and this was 20 years ago, that he still has nightmares about this. I mean, but the Supreme Court does not, or any of the appellate courts do not realize that every time they order a resentencing, the family members have to relive the most horrific day in their life. This was 20 years ago, and these folks are being exposed to this again. There is nothing that I can do about that. I have to follow the law. The law says that I must impose a minimum sentence somewhere between 25 and 40 years and a maximum sentence of no more than 60 years. I am aware that 20 years ago you were found guilty of 3 counts of first-degree murder and sentenced to a life with no possibility of parole. This, as the prosecutor has said, and I agree with her assessment of this matter, was one of the most horrific and brutal and outrageous, at least that I have ever heard of or been aware of. I have now been practicing law 37 years. I've been 17 years on the bench. I've done over 150 murder or death cases, and this is clearly the worst and most egregious murder that I've ever been involved with. You ended up, your mother, your 15-year-old sister, your 6-year-old sister. You took a knife and cut their throats. You took a baseball bat. You beat them. You violated your 15-year-old sister with the bat after you were done. This is beyond words. I am aware of all the Miller factors. I will incorporate by reference everything that I've placed on the record at the hearing in this matter to determine that under the law you should be resentenced. I am balancing everything. I have listened to the prosecutor. I've listened to the defense attorney. I've read the memo. I am familiar with all of the facts and circumstances. But it is the sentence of this court, sir, on these 3 counts of murder that you be committed to the Michigan Department of Corrections to serve a minimum of 40 years to a maximum of 60 years. You have served about 20 years now. You're entitled to 7,434 days of credit. You have another 20 years to serve, and then, quite frankly, it is up to the Michigan Department of Corrections if you ever get out before you're 77 years old. There's $204 in state costs, $130 crime victim rights. I'm also considering all of the issues under not only the Miller factors, but People versus Melbourne, People versus Lockridge. I believe this is proportional and reasonable. Accordingly, this is the final sentence of the court. You're receiving a form that explains your appellate rights. Sir, I hope you continue to think every single night of the horrific murder that you did and what you did to your family. Take him to prison, please.
John Seisling was sentenced to life in prison without the possibility of parole for the brutal murders of his mother and sister. Gerard Juan Cook, 37, has been charged with murder in the Rock Hill case involving the death of 59-year-old John Farrell, who was beaten with a hammer. Cook had been released from a South Carolina prison after serving 18 years for 28 felonies.
Yeah, I take it you've been served with the arrest warrant, and the warrant says that you beat the victim, John Farrell II, to death with a hammer in the head and upper body area. That this incident occurred inside the victim's residence.
Officers of the Rock Hill Police Department responded to a death investigation crime scene. It quickly became apparent that the gruesome scene was that of a brutal attack and homicide. Through further investigation, it was determined that the victim, John William Farrell II, died at the hands of his acquaintance, Gerard Juan Cook, hours before police were called, and that Cook had struck Farrell numerous times in the head and upper body with a hammer. Cook then tried to destroy the evidence in an effort to remain undetected as the suspect in the crime. Cook was charged with murder in this case, and we respectfully request the court to consider these facts when making any decision as it relates to Cook's bond.
What is this from? From what event would you be on community supervision?
I just did 18 years in prison. Straight.
Okay. And so?
Got locked up really young, and I just got out probably over a month ago.
Okay.
So that's why she's.
I take it your supervisor from Probation and Parole is going to know where you are. And as I told you, you do have a lawyer now, and that lawyer will find you. But your bond's denied, you're going over to the county. And I can't tell you when you get in front of a judge. You have to go in front of the circuit court judge to have your bond set.
He was sentenced to 18 years in prison again after he pleaded guilty in York County Criminal Court to voluntary manslaughter in the beating death of John Farrell. In October 2023, David Piatura committed a shocking crime by killing Prince McCree in Milwaukee. Now, he is waiting to see the court's decision on his actions. Although Piatura has admitted his guilt, he continues to appeal as part of the legal process and has made statements trying to prove his innocence.
When we look at this case, the facts of the case are as horrific as it gets. The actions of Mr. Piatura are nothing short of evil. And I don't say that lightly at all. I don't know if that makes him evil, but it certainly means that his actions, I think, were. I can't speak to what's in somebody's heart. I certainly can't speak to what's at their core. What I can look at, though, is what distinguishes this case from other matters that I've had. The facts are horrific. There's absolutely nothing I'm going to say that is probably not likely going to offend the victim's family, and that's certainly not my intent. But Mr. Patura did plead guilty. Mr. Patura did take responsibility for his actions. I understand his comments to the PSI writer, and I understand his minimization. But ultimately, he stood in this courtroom before Your Honor and did not avail himself of trial, did not put his family, Prince's family, through a trial. And whatever that measure of remorse and reflection that shows, at least it shows something. I don't know to what degree, but it does show something. And that's why I'm going to ask this court not to impose life without the chance of any parole. I don't, as the court notes, the law requires life, and the minimum is, after 20 years. I'm not going to ask for 20. But I sit here and look at Mr. Patura, and he's 27 years old sitting here today. And I certainly don't know the answer, but when I look at the fact that for whatever reason he has no record, for whatever reason he was able to plead guilty and spare the family a trial, and for whatever reason he acted in the most egregious, evil manner that I've seen in my career. So what do we do? And I think at the end of the day, and I quite frankly commend the family for their forgiveness in a lot of ways, and their recognition of the reality of the situation. I'm going to ask the court to impose a life sentence with the chance of parole after 40 years. That puts Mr. Patura at age 67. And that only makes him eligible. And I want that, and I know the court knows that. This isn't saying he gets out in 40 years. But it says that we take a look. It says in 40 years, when Mr. Patura is of retirement age, that we take a look and we see if there's a reason to let him back out, to live out whatever years he may or may not have left at that, or whatever years he will have left at that point. And maybe, and I don't know this, but maybe there's some contribution to society that can be made by Mr. Patura, both while he spends his time in prison and if he ever is released under my request. I can only hope that this isn't entirely blanketed with evil and that there is some sort of light, whatever that might be. And I'm going to ask the court to follow that recommendation. Thank you.
Thank you. Mr. Piatore, this is your opportunity if you wish to make a statement or an allocution to the court. Do you wish to make a statement, sir?
Yes.
Right. Please pull the microphone close to Mr. Piatore.
I agree with what the aunt said about with the death penalty. It is a shame that we don't have it here, because for my involvement, I feel that death would be right. But we only have life without parole, and I think that I should get life without parole for my involvement. And I know that goes against what Mr. Russell says, but regret and guilt, I had a lot of time to think about everything, and this shouldn't have happened. And if I had a chance to change it, I would, but we can't go back in time. We can't change things that have happened. All we can do is continue on forward, and Prince can't do that no more. But I can, and it ain't right. And I don't think the family would. I know they said that they, to be completely honest, I'm surprised they didn't try to go at me 100%. And for what they did, that's big of them, I'm not gonna lie. But if there's no possible way I should get parole. I don't think I should. I don't. But I don't think I'll ever be able to forgive myself. They show that they're capable of forgiving me, but I wouldn't be able to forgive me in that position. I wouldn't. I wouldn't. That's all I really have to say. I know it's not much, but that's all I got.
Further, you should undergo and complete a course in thinking for a change. How to change your mindset so that you can comport your behavior with the standards that are expected of people who are actually in our society. You are to have absolutely, positively no contact with the parents or family members, that is anyone from Prince McCree's family. No contact means in person, no contact means by letter, no contact means over the telephone, by internet, by text, tweet, or any way, shape, or form. No contact. That is the only way that these folks will be able to move forward with their lives and have some peace. Further, sir, you are to have no contact with firearms. I will order DOC to collect any monetary amounts ordered today, which include giving a sample of your DNA to the state crime lab and paying the DNA surcharge, as well as paying all mandatory court costs. Was there any restitution requested?
I don't believe so.
Was there restitution requested from the advocate?
No.
Restitution shall be set at 0. So DOC shall collect any monetary amounts ordered today for those court costs as provided in section 973.05 sub 4 sub B and 973.20 while you are in their care, custody, and control from your accounts. Any monetary amounts that remain unpaid when the sentence is completed, which will be a life sentence, would be reduced to a civil judgment against the defendant for unpaid balances, and then collection could proceed under section 71.935 of the statutes, as well as through other civil collection means. Mr. Piator, this is a life sentence. Therefore, while I recognize that you have 275 days of pretrial incarceration credit, that does not get awarded to you. It is just simply notated. Sir, you have been convicted of a felony offense. Therefore, you may never possess a firearm at any time in the future. Section 941.29 of the Wisconsin statutes makes it another felony for anyone who has been convicted of a felony to ever possess a firearm, carrying with it its own 10-year period of imprisonment or $25,000 fine or both. Sir, do you understand you may never possess a firearm?
Yes.
In addition, due to the felony conviction, you are prohibited forever from possessing body armor, ammunition, and explosives. Do you understand that?
Yes.
And finally, sir, you are not allowed to vote until your voting rights have been restored by the Department of Corrections if you are ever discharged from this sentence. Do you understand that?
Yes.
This case leaves me so disturbed. And it leaves me so saddened because the potential for one life is extinguished, and the other life is going away for the rest of his. We, as a community, need to hug our children. We need to take our kids and tell them that they are good and give them examples so that they can live a good life and know how to treat others with dignity, respect, and have that moral compass that hopefully will ensure, given this sentence, Mr. Piatora, that other people will learn that this can never repeat itself again. That's the message that I want sent to the community, that Prince McCree's life was valued, and that unfortunately you've taken that away from not only his family but our community. And in spite of that, though, Mr. Piatora, you're going to live the rest of your days out in the Wisconsin State Prison System. All right. Mr. Piatura, if you are dissatisfied with the sentence that the court has imposed today, you have 20 days to appeal my decision. I'd ask that the CR 233 form be filled out and filed with the court. Sir, you are advised that you have the right to seek the assistance of the Office of the State Public Defender in prosecuting any post-conviction motion and/or appeal should you wish to do so. And if the voting rights admonition form is not on file, it should be signed and filed today.
It will be.
Are there any questions from the state as to the sentence imposed?
No.
Attorney Jones, do you have any questions about the sentence imposed?
No, Your Honor.
Mr. Piatura, do you have any questions, sir?
No.
Right. Then at this point in time, I'm going to ask that the family of Prince McCree please peacefully rise up, and you're to leave the courtroom in an orderly manner with the victim advocate.
A judge has sentenced him to life in prison without parole. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.